Good morning. Happy Tuesday. On the Earl appeal issue, just so everybody's kind of understanding the timeline of where we're at, remember, Earl was convicted at trial. He filed an appeal. I think his appeal had merit. That doesn't mean it's going to win. I gave him like a 20% chance of success, or I gave him a very low chance of success. I think it was 20%. His appeal was denied. His attorney filed a motion for rehearing or a motion for a rehearing en banc. He filed both, rehearing and rehearing en banc. En banc means that instead of just the three justices, it's going to be a group of like more, like 9 justices or something like that. In theory, it could be the entire appellate court of appeals, that district, whatever. It could be all of the justices, but it'll probably be like 9, 6, 9, whatever, 12, who knows. So he filed those two motions. The state also filed motions for rehearing and rehearing en banc. They didn't like some of the dicta, some of the way the Court of Appeals phrase things, because they think it's going to hurt them in other cases, which, in my opinion, shows that it wasn't a really good decision by the Court of Appeals. If neither side is happy with it, then there's probably a problem with it. I know I wasn't particularly happy with it. I felt like they hand waved away a bunch of stuff that they shouldn't have. And again, I hope Earl gets a new trial, a new clean trial. I would guess that Earl is going to end up losing still. But anyway, that's not the case. That's not what we're talking about right now. So each side filed motions for rehearing. The Court of Appeals asked each side to respond to the other side's motions. The deadline came. Earl's attorney filed a motion for an extension of time. That was granted. And then Earl's attorney filed their response, not opposition, but response to the state's motion for rehearing. The state hasn't filed anything. So my best guess of what is going to happen is there is a high likelihood of the court granting a rehearing. There's a less high likelihood of the court granting a rehearing en banc, but neither one is guaranteed. I would say 60-40, 60% chance of success on getting a motion for rehearing, 40% chance of success on that motion for rehearing being a motion, or success on the motion for rehearing en banc. So it's not like 60 plus 40, meaning 100% chance of some kind of rehearing. No, 60% chance of a rehearing. Of that 60% chance, is about 40% chance. So 4 times 6 is 24. 24% total. So if you do it out of 100, 24% chance of rehearing en banc, roughly, and then a 36% chance of rehearing, and then a 40% chance of no rehearing at all. That's best guess, pure scientific wild ass guess on my part, but that's kind of where I'm seeing it. I don't think the state is going to be forced to make a response. I don't think the state is going to be smacked on the pee-pee for not responding. And my best guess is on the actual rehearing, my best guess is that Earl will lose. I would put his odds right back around again, around 20% chance of success on the motion for rehearing en banc if granted. If he gets the rehearing, I think he has about a 20% chance of getting it remanded back to the trial court for a new trial. That's my best guess. And again, my giving it a 20% chance of success is based on how good his arguments are. I think he has excellent arguments for appeal, but the appeal process is stacked against the appellant. It's difficult. The presumption is that the trial court's ruling is final. So, and that's done to kind of bring an end, give people a sense of finality. It's this stuff isn't supposed to drag on for years and years and years. And in Earl's case, it is dragged on for years and years and years, and it'll likely drag on for years and years and years more. As he exhausts this, he'll probably try to petition the Arizona Criminal Court of Appeals, which is the highest criminal court. They're separate from the Supreme Court that handles criminal issues. The Texas Supreme Court just handles like civil issues. So it's not the Court of Appeals, it's the Texas Court of Criminal Appeals, because why not be confusing? So he'll probably petition for writ of certiorari to them. If that fails, he might try to petition for Supreme Court review, because he does raise some issues that involve due process and, I think due process. I don't think there's any other Fourth Amendment issues, but anyway. So this could take a while. So then let's switch over to Chille Decastro. Chille Decastro, once again, he did an 1.5 hour long video to try to explain why he prepared and filed his new defamation case against Kate Peter, Josh Abrams, and Lackluster. The problem is, if you have to make an 1.5 hour long video to explain why you filed a complaint, then your complaint is shit. Like, if your complaint doesn't state specifically why you're filing your lawsuit, that's a problem. But I'm not really going to spend any time on Chille, because this is just an effort for him, in my opinion, to get publicity, to get clicks, views, to get people to watch his stuff, to try to generate YouTube revenue. He doesn't have any odds of success on this. He knows this. Everybody knows that this case is a pure loser. There's no chance of success. Normally I say that there's like a chance of success. A court can make a mistake. There's no chance. This is just like, there's nothing redeeming in the complaint. There's nothing of value in the complaint. It is a pure loser. It's like suing Ohio for something that has already been ruled on in the district court in Ohio, trying to sue them in Nevada. I mean, it's just a pure loser. There's so many. It's like, that's why I didn't cover it, because the Ohio case in Nevada, because there's just no way of success. He has no possibility of success, just none. So it's a non-starter. All he's doing is he's trying to, in my opinion, trying to generate interest, trying to generate clicks and views, trying to generate ad revenue, hopefully get some people to send him money, super chats, whatever. This is not done to actually prevail in court. That's my opinion. So I'm kind of hand waving him away, because it's just such garbage. Like, there's nothing redeeming even to start an analysis of. There's just nothing there. So like, if it doesn't go away on res judicata or collateral estoppel grounds, it's going to go away on failure to adequately plead diversity jurisdiction. It's going to go away on failure to state a claim upon which relief can be granted. It's going to go away on statute of limitations issues. It's just, I mean, there's just nothing redeeming to it. There's just no way. There's just no way. There's just no way. He has to plead defamation per quad, and he hasn't even done that. Like, it's just stupid. So, on Springer versus 7th Judicial District Court, that appeal has been pending. Everything has been filed and waiting the justices to look at it and render an opinion, or even perhaps grant oral argument. That's been done since, I think, April 29th. So more than a month of the Court of Appeals just sitting on it. I looked to see their oral argument calendar. They don't have it on their oral argument calendar, at least not yet. So I don't know where that's going. Once again, that's the case where it's A. Blair Dunn making complete shit legal arguments, and he's being opposed by something Delphine, like Jasmine Delphine, who's representing the 7th Judicial District Court, who's also making complete shit arguments. And the only one who actually understood the law in that case was the judge. And so 7th Judicial District Court has been winning despite its attorney's efforts, and Springer's been losing not just because the law favors or disfavors his cause of action, but because his attorney can't seem to quote law. His attorney can only quote like Thomas Jefferson and other founding fathers and their ideological aspirations of what freedom should be, and and courts don't operate on those. Courts operate on, like, here's a 10th Circuit decision that says that I win. Here's a statute that says that I win. Here's a New Mexico state court case that says I win. Here's a Supreme Court case that says I win. That's what he needs to be quoting, instead of quoting like Thomas Jefferson. I mean, Thomas Jefferson was a great writer, and sure, a lot of people love his ideas, but they're not binding on the court. Those are political writings, not legal writings. And I don't know why his attorney can't seem to wrap his brain around it. You're an attorney, bro. Act like one. And finally, we have Lane Myers, who allegedly has taken a plea deal. Now, what that plea deal is, I don't know. Is it a good plea deal? Without knowing what he pled to, I don't know. I hope that he got a plea deal as good as or better than the one he attempted to plead to last time. By the way, everybody who said that plea was just a ruse to do something stupid and, insert nonsensical reason for taking a plea but then fucking it up here. I mean, so many Lane Myers retards in my comment section trying to grasp at anything to justify that nonsense that Lane Myers was doing, for being incapable, just completely inept, to the point where he couldn't even fucking take a plea deal successfully. And for those people who thought that was a ruse, well, I guess once again, Daddy Right, you're wrong. Say you're sorry. Donate to my GoFundMe account. Whatever. G-string account. NordVPN. It's not for Gajits. Use the link in the description. Support the channel. Whatever. Apparently people like the NordVPN plug. I don't know. So anyway, Lane Myers allegedly pled. Allegedly, it appears that he has a sentencing hearing on the 1st, July 1st. So I suppose sometime between now and then it'll leak what he pled to. It will be interesting to see what he pled to. I hope he got a better deal. He might have got a worse deal. As you get closer to trial, as you piss off the prosecuting attorney more, you can get a worse deal. There's nothing preventing the prosecutor from unsweetening the deal. So, I do want to address. There was a comment left in my comment section, like maybe yesterday, maybe the day before, about someone who's saying that, like, Lane Myers is, he should be congratulated or encouraged, not criticized, because he's fighting the man and he's standing up for his rights and for all of us and this and that. And no, he's not. Even if I grant you the argument that he was wrongfully targeted for booing and he was wrongfully prosecuted for booing, and I just grant you all of that, that is a completely separate issue, legally speaking, from him deciding to harass the wife of the prosecutor. I understand that you guys all think that it's all a sequence of events that started with him getting targeted for booing or whatever, leading up to him harassing the wife. He's forced to because she's married to the whatever your rationale is. None of it makes sense. It's completely separate legally. He is getting prosecuted for harassing someone who, at the time he started harassing her, was a minor public employee, not a public official, a public employee, and a minor one who didn't have a public-facing job. She wasn't a secretary. She didn't give press statements. Like, she's a bit player in a law school. And even if she was a major player, she's being harassed about things she has no control over. Like, I don't understand why people can't grasp this. He was not fighting for he's not fighting for your rights to do anything except for some alleged right to harass public employees simply because they're employed by public entities. And that's nonsense. Like just because someone's employed by a public entity, there's no statute, no case that I'm aware of that says that just because someone's paycheck comes from a state or federal entity that you can harass them. And I mean, if you want to draw this out, like, does that mean you get to harass people who are on food stamps? Well, you're taking public money. It's stupid. It's nonsense. It's insanely irrational. If our society was built that way, it would not perform well. People would not take public jobs because then all of a sudden, if their neighbor gets a beef with them over the apple tree dropping apples on their side of the fence, then all of a sudden they could just harass them night and day. And that doesn't make sense. None of it makes sense. None of it makes sense from a societal level, and there's no legal argument to back it. So he's not fighting for us. He's not fighting for you. He definitely deserves criticism because what he did was pretty shitty, picking on the wife of a prosecutor because he's getting prosecuted. If you have a problem with the prosecutor, you deal with the prosecutor. You use the legal system. He's an alleged attorney or better than one. So fucking use the legal system. Except he can't because he's inept. Because he's not better than an attorney. Because he doesn't know better than an attorney. Because he's fucking retarded. He's a convicted felon who has now pled guilty to at least one or more felonies. So do with that as you will. Maybe he's qualified for the law firm of Stout, but he's not qualified to be an attorney. Anyway. So there's a lot of wondering why, get into the mindset of Lane Myers. There's a lot of wondering as to why he did it. At least in my Discord, there's some wondering, and I'm sure other people are wondering. And one of the theories that was put forward was maybe he's concerned about his wife being deposed. First of all, she's not his wife, and second of all, her deposition would be limited to things relevant to this case, things she knew, things she heard Lane Myers say. I don't think, and she's an attorney, so I think, hopefully she knows how to handle a deposition, and she would know how to handle being deposed. Like, the last thing I would worry about as an attorney is someone wanting to take my deposition, because you're not going to get a goddamn thing out of me that I don't want to give you. You're not going to trap me in anything. You're not going to get what you hoped. You depose me, you're not going to get what you hoped you were going to get. Anyway. My best guess is the reason why Lane Myers is taking the plea deal is because Lane Myers' original attorney, Parvin, told him you're fucked. Lane Myers' replacement elbow counsel told him you're fucked. Lane Myers in every motion has been fucked. I don't think, I'm going to go out on a limb here that Lane Myers' girlfriend has told him you're fucked. You're fucked. He doesn't, there's no way out. There's no win in this. He published his crimes. I know Lane Myers supporters don't think those are crimes. I get it. I understand what you're saying. But all the lawyers think they're crimes, with the possible exception of Eline, who's barely a lawyer. But all the lawyers who matter, whose opinions matter, think they're crimes. The judges who've reviewed them have found them to be harassing. Every single judge who has made any ruling in this matter based on the crimes hasn't had any issue. Those are crimes. If Lane pled, that means Metcalf was aware that what these things were crimes. The other judge, the presiding judge, she was perfectly willing to take his plea deal as long as he actually admitted that he could plead that she felt harassed by it, that she was reasonably harassed by it, that she felt she was reasonably in fear for her safety or the safety of her family. No judges have said this is a First Amendment issue. None. When he's raised First Amendment issues, quash, done. Not quash, but denied. So I have a feeling that Lane Myers fucking clicked. It might have taken a while, but it clicked that he's fucked. That's what I think. That's why I think he pled, because he's fucked, and he got a better deal than he would have if he went to trial. That's my best guess. So good luck to you, Lane Myers. I'll be rooting for you on July 1st that you're able to actually express sorrow, remorse, guilt, and that you can get some mitigating factors going for you, because being a prior felon, I think, are aggravating factors. So man, like, I hope you get some good coaching by your attorney. I hope you listen to him, and I hope that he can get you to properly express responsibility and remorse for what you did, and that he can get you to apologize and look sincere in doing it to the victim. Anyway, that's all I got for you today. Thanks for watching. Have a great day.